Hey, Colleen.
Hey Ken, how you doing?
Good. How are you?
I am good. I forgot my water in the other room. I may have to go and grab it in a second.
Sounds like a good idea. I filled mine up just a few minutes ago.
I will be right back.
Okay.
Sorry, Alfie. Okay, grabbed my water, stepped on my dog in the process. It was great.
There you go.
Yeah. Well, he insists on laying as close to me as possible. So
Sounds like a good dog.
line.
That's a good dog.
Yeah. Yes. I guess this is our first one of the new year. So how's your new year been?
Hectic. It's at work. Otherwise, it's okay.
Yeah.
How about you?
Spent the first week of it sick and
Oh, sorry.
my partner who had COVID. I didn't have the COVID. I just had an illness. And so
We've had a fair number of people, well, really more than a fair number of people. I think if I count up everybody that either had it or had a family member that had it and resulted in them being out of the office, it was like it was like 10 to 15% of our workforce.
all of our intake specialists had it at the same time the whole first week. Like, and we were doing that clinic for the Meadows with Jack Porter's office.
No.
And we were like so short staffed and just didn't have the people that we needed to support.
We closed our Northeast branch office out of, I think, 8 people, 5 of them came down with it. I think 5 came down the first week, and then the others came down the second week. So we only opened it, I think this week. I think it was we were out. It was closed for 3 full weeks. We worked like 1.5 weeks with some staff in there, but we didn't open it to the public because we didn't have enough staff to open it.
Yeah.
And
Yep. Sounds right. Hi, Ian.
Hello, everyone.
Hi. How you doing?
It's a pretty spiffy library you got there.
I know. Well, it's better than seeing my bourbon collection behind me.
No, I'd rather see the bourbon collection. So speaking of that, I got an email. You probably got one too at one point. I got something that said, you've been granted access to the vault at ABC Liquors. It's open till like 11:59 tonight. I went, what? Well, okay. So I clicked on it and it brought up all these different bottles of bourbon, most I'd never heard of. Half of them were already sold.
Yeah.
So I bought a bottle of Eagle Rare 10-year-old Kentucky bourbon.
Nice.
I don't normally drink anything like that, but I tried a couple sips of it and it was pretty good.
Well, for you to get on the vault, that means you go to ABC and at least get something else you like a lot.
My spouse has gone there a few times recently.
Yeah.
I think she stocked up for the Christmas holidays there.
I don't check. The mistake I made was I put my Comcast email as an email where ABC would inform me of that. And I hardly check it. I don't have it set to ping on my phone. Otherwise, my phone would be going off all day.
Yeah.
And so there's several times where I've gotten the vault email, and by the time I saw it, sometimes it was like the next day and the window had already closed.
Yeah.
So I missed out completely. Yeah. When you
I've
get
never
that vault
gotten this
email,
email about the vault. I have no idea what you two are talking about. I do not drink enough.
sometimes you can, like, if you have a big party and you get like a case of wine or something, you can rack up enough points to where they put you in the hopper for that.
My liquor bottles need some dusting off.
That's something to be proud of, Colleen.
Yeah,
None of
well,
mine need dusting.
I'm doing dry January right now, and I don't tend to drink a lot anyways. I overdid it over the holidays for sure, but yeah, it's just not a thing I do much.
It's for me, I'll have a beer. I had a beer last night. I went to a reception and they had proof 850 on the menu. So I got that.
It's good beer.
It is
Yeah.
good.
I think I'm gonna make a pale rye ale this weekend. I got some rye that's been sitting in the closet with my other grains, and I'm trying to figure out what do I brew with rye that's not whiskey. And I found a couple of recipes to brew an all grain beer with rye. So
Pale rye ale. That sounds interesting.
yeah. Well, I'm trying to brew up enough for the brews by the bay. They do it over in Panacea, and that's coming up in March. And so I normally have a booth there. So I'm trying to restock up my beer because I went through like 40 gallons of stuff that I made back in January for the Tallahassee Beer Fest. So now my stock is dwindled and I have to start brewing up again.
Who knew you're a master brewer among other.
I wouldn't call myself a master brewer, but I brew.
That's awesome.
Enough for Gren Graybar to keep inviting me to events.
There you go. That's worth it.
Mm-hmm.
I don't know about you guys, but I'm happy the week is almost over.
It's
Yep.
it's been crazy.
Yeah, it's just been crazy since the beginning of the year, but also much longer.
That's good.
So I've got Charlotte on standby in case I mess up the live stream again, but hopefully we
Okay.
can go live in a few minutes. And we do have 4 attendees so far.
Wonderful. We really tried. I did not get any questions, but I had one gentleman who said he had questions and he would like to ask them, I guess, at the question part of the presentation.
Okay.
Yep, and for the attendees who are already on, you all, if you want, can start sending questions via the chat feature, and we'll start answering them as soon as we go live, I guess.
Okay, and yes, we have one of the attendees that says that she has questions. That's wonderful.
It's good, yeah. Let me give it one more minute and then I'll go live on the Facebook as well. And if I go on mute, it's only because my dogs are probably barking at something. Right now they're being very peaceful and sleeping next to me, but it's no guarantee of good behavior the whole night. So
Well, being a dog in good behavior is not synonymous.
I do have my little sidekick though with me.
Oh, awesome. That's a baby Yoda.
it is a baby Yoda.
That was cool. We
Call it
have a
Probate
question.
Yoda.
Yeah, we have a question so far.
Yeah. I'm gonna go ahead and go live. It'll take probably a minute to connect to get the Facebook actually working, but give it 1 minute. Okay, looks like we are live and I can see myself multiple places on my computer, which is super fun, you guys. But I'd like to welcome everyone to the Legal Services of North Florida and Leon County Clerk's Office Probate Law Clinic, featuring our brilliant attorney Ian White from Osley McMullen, who, if everyone doesn't know, Osley McMullen was recently given an award by the Florida Supreme Court for their excellence in pro bono service. So I wanted to pass along my thanks to you, Ian, because you weren't at the ceremony for me to thank you, but you were one of the people that I was thinking of.
I was out of town, sorry.
That's okay. But yeah, Osley McMullen is a fantastic firm in town, and Ian White is one of their brilliant attorneys. He does probate law, so he is here to answer any questions. And I'm gonna go ahead and start asking him the questions that we've already been given. And then Ken Kent from our Leon County Clerk's Office is going to fill everyone in on what the clerk's office is here and can do for you even in pandemic times when COVID is striking all of us down.
Especially in pandemic times.
So our first question is that one of our attendees' dad passed away in January of 2022. It was January 12th, so only about a week ago, and I'm really sorry about your father, sir. The house and property has always been known to be willed to me, his only son. However, the widowed wife amended the deed September 25th of 2021 and added her name to the deed. He says his dad had dementia for the past 6 to 8 months, and I'm guessing he's kind of asking what recourse he has.
Okay, there's several things there between before you get into the probate side as to the validity of the deed. Florida is really finicky about undue influence. That's basically what you're getting at, is whether the father was unduly influenced with the inclusion of the surviving spouse on the property. Now, you may have already mentioned this, Colleen. Was this the father's homestead?
The gentleman didn't say.
I'll answer it both ways. If it's the homestead, and generally the way succession of homestead would work is that if he is not the biological son of the surviving spouse, but he's the biological son of the father, then the way this works is that the surviving spouse is automatically entitled to either one of the following: either a 50% interest in the property, and then he would have a 50% undivided interest in the property, or she can do what's called a life estate. If she's going to elect that life estate, she has to do it within 4 months of the date of death. And but absent that, I think that even though let's put it this way, if she had not been added to the deed, then under the probate code, so just put away the undue influence, her being added altogether, under that situation, by her being added, she would have already been entitled to either a life estate. So that way it means she could live there on the property until she dies, or she decides she wants to leave and give up that life estate, or she would have a 50% ownership, which, and then he would have a 50% ownership. Generally, the surviving spouse is still living there. She just has to then, do the upkeep and stuff. So I can't answer it with every completeness because I don't have all the facts, but I'm trying to answer it, whether it's homestead. Now, if it's not homestead, that's a different matter, because then you take the Florida Constitution out of the framework about automatic vesting and who receives the property. Now we're back to the undue influence, and that's really tricky. There's a lot of elements. There's about 7 elements that you have to prove that there was undue influence, and it's very hard to prove that. And in other words, you could have I've heard all the time where they say that the father or the mother had dementia or was on heavy medication and didn't know what they were doing. Well, these documents are being notarized, and so it requires a lot of players to kind of be in on the fix, so to speak. Not to say that it can't happen, but if you believe that there was potential undue influence, I'm not saying give up on it. It's a high bar to undo and try to unravel that. You should probably talk to an attorney so they have a better idea of exactly what type of asset we're dealing with. And then if all of the certain factors seem to come into play, or at least most of them seem to come into play, then it might be worthwhile to then hire someone to look into it further and determine. But I've had this come up before in a probate setting where even I, after talking to the client, thought that there was some undue influence. But once we got into the meat of it and spoke with the other side, we realized we weren't able to hit all of the elements. And so although some of the elements were there for undue influence, they weren't all there, and therefore we weren't able to undo the deed. So, you know, I'm not saying that it's a possibility, but yes, a bundle of sticks and Whiteacre, yeah. But yeah, that undue influence part is there, but in Florida, it is a high hurdle to try to unravel.
Okay, and that person actually had one more question. He says, I'm guessing the dad's personal property, like guns, vehicles, etc., that would definitely have gone to him, has already been sold by the wife without the attendee's knowledge, and nothing has gone to him. I'm guessing
Okay.
He's wondering what his recourse is on that.
Well, you know, obviously, once it's gone, unless it was recent enough. Like if they say they went to a pawn shop and turned it over, you might be able to try to get it back, or if you know who it was sold to. But the reality is that the code doesn't say that you're entitled to the actual tangible thing. It just says you're entitled to a certain percentage of the estate. So again, if he is
It may be that he was willed that property in the dad's will, in which case.
Yeah, you don't know. I mean, without seeing the will, I don't know. Most wills will say everything I have goes to my surviving spouse. But usually if it's a second marriage, then they'll say, I want my children to receive X, my surviving spouse to receive X. I'm answering the question as though if there was no will. And if there's no will, then this takes me again back to, was the surviving spouse the biological mother of this person or not? And if she is not the biological parent of this person, then he would be entitled to half of the estate. So therefore, she sold the guns. She shouldn't have. She should have probably given him the option to see if he wanted any of them first. But now they're sold, and whether they can be recovered, that's a whole separate thing. But he, at a minimum, he would be entitled to 50% of what she sold it for. So his options would be to go and make that demand that she would need to pay him 1/2 of what she sold it for. And then at least under the probate code, he would be made whole from a financial side. I understand when you get into guns and some other items, there's some sentimental value to that. And sometimes you just can't put a price on that. And, you know, so yeah, it's easy for me to say whatever it was sold for is 50%, but I understand the reality is that some things just are too precious and the value is through the roof as far as, you know, the beneficiary is concerned.
Okay, we have another question from one of our attendees. She says that she has some probate questions. First is, she received paperwork, a notice from FloridaTreasureHunt.com regarding unclaimed property or unclaimed funds, I guess, from a grandparent. It's been a long, drawn-out process. She thinks she's in the final stages. She's supplied the requested birth certificates. Thought she was done. Sorry, the scroll feature on this is a little difficult. I'm going to open this chat a different way. It's not letting me. It's really annoying.
I can see the chat, and it says it looks like they're trying now. They're saying that they need to do formal probate. And they don't know what that means. So that gets into part of the description I was going to mention. So this works out great. There are 3 types of probate in Florida. The 2 main ones are formal probate. In a formal probate, a personal representative would be appointed, and it's mainly used for estates where the personal representative is needed. Like, for instance, to gain access to a bank account, maybe to gain access to these sort of assets that the state's holding, to sell property, or if you have to bring an action or defend an action against the estate. That's typical where formal administration is needed. Then you got summary administration, and depending on the how long ago the grandparent passed and the amount that the state's holding. I would be very shocked if the state is holding, 70-something thousand dollars. But if it's a recent death and the assets that the state is holding is 75,000 or less, then and assuming that if you add up all the other assets of the grandparent, they all combined minus the exempt assets like the home, you don't count the home value in this. But if the assets minus the home are 75 or less, you'd be in summary administration. So you wouldn't need to do the formal probate that they're asking you to do. And summary is a lot faster. The way I typically do my summary administrations is I'll even have verbiage in the petition that says that the share of the estate, any and all assets that the state may be holding goes to the beneficiaries and whatever the appropriate share is going to be. And then ultimately there's an order that would be felt signed by the judge that would correspond with that and would mention any and all assets that the state's holding. It would go ahead and distribute that. And then that order is what you would give to the state, and then they would disperse pursuant to the order. So that wouldn't necessarily require, from what I'm seeing here, I don't think a formal probate would be necessary. I understand that a lot of these institutions even invest like stocks. They're always asking for letters of administration or a personal representative to be appointed. A lot of times that's not really needed. They're just used to saying that, but you can get access to the same asset through the order from a judge, which is the order of summary administration, as long as the probate qualifies to be summary instead of formal. It sounds to me, when you've got assets that are there by someone like the grandparent, the only way you're going to get them actually dispersed is through a probate process. So I think summary is the way to go here. All things being equal, obviously I would change that if the assets increased when we're above 75,000.
Sounds good. So she's asking what probate form she needs to submit for a summary administration. And I think that's a question I'm going to reserve for Ken when he describes the forms on the Clerk of Court website. Is that all right with you all?
Give it a shot.
All right. The next question is, who can start a probate case?
In a summary administration, that can be started by any interested party. So it does not have to be the actual beneficiary that's to receive. It could actually even be a creditor of the estate. So any interested party to the estate can file a probate. And that's even formal administration or summary. But typically you see it more in summary, where you'll have someone that's not, especially if there's no will, that doesn't direct someone to be a personal representative. The biggest difference between a formal administration and the summary is that in a summary, there's no personal representative that's appointed. So even if the person had a will that says, I want this person to administer my estate, if the estate doesn't need to have a formal administration because it's small enough, then you would go summary, and usually the one that was named in the will would be what they call the petitioner. So the petitioner would file the summary administration and ultimately get the order that disperses the assets according to the person's will, or if they die without a will, then it would flow under the intestate laws of the state of Florida. And the other probate that I didn't mention, I don't handle it because it's small. There's one's called disposition of personal property without administration. And that's really when there's no real property. You can't do that. It has to be personal property only. There's some other caveats to it, but generally that's the biggest difference. And the amount is has to be under a very small threshold, just a couple $1,000s. If you've got a lot of value, then you would be bumped back up into summer administration. And if it's over 75,000, then it'd be formal, except for the fact that if the person's been dead for 2 years or more, then you can do a summary without going formal. It just depends on whether you think you need really, it always boils down to whether you think you need a personal representative or not. If you do, then you need to go forward.
Okay. Next question is, my dad passed in December 2021. My mother had passed in May of 2018. There is a home, but no will, with 4 siblings. Her sister is trying to claim the home and live in it. How can I file to get my portion of the property? And can I sue her for my portion of the home?
Well, unfortunately, yes, sometimes that does happen if you can't agree. It's not that you got to sue for your portion. Right now, both parents are deceased and we're dealing with the homestead property, correct?
It sounds like it, yeah.
Yeah. So again, under the Florida probate code, when the last parent is gone, then the homestead protection stays in place and it automatically vests to the children. So in that scenario, however many children they all get an equal share. So you don't have to sue to get it, because under the Florida Constitution, that right vested immediately upon death of the surviving spouse to the decedents of that parent. So however many kids there are, it automatically vested them. The only way for legal title purposes, you got to open up a probate and they file a form that's called a petition to determine homestead. It names the beneficiaries or the heirs of the estate. And then you get an order that says, yes, these are the individuals that are now the new owners of the property. That document gets recorded for title purposes. That way they have clear title. So that process isn't necessary litigation. It's just more of a filing the appropriate paperwork to officially get it into their names. The next stage is, okay, now if you can't get people on the same page, some person wants to live in it, but they don't have the money to buy out the other sibling, or they're at the disagreement because one wants to sell, the other one doesn't want to sell. That does become litigation. And then that's like a partition action where they'll have to bring an action in court. And basically now the judge is going to do a forced sale of the property. And then the net proceeds are still split equally, but no one comes out well there, because normally you're hiring counsel to file it. So you got attorney fees, court costs. And when you sell a piece of property as a forced sale, you're not getting the full fair market value of the property. It's normally being sold at auction, public or private auction. So that's not the best scenario. It is better to try to work that out amongst the siblings if possible. Especially if one says, no, I really want to live there, then it's like, all right, then buy me out. And they try to work through that.
Okay. So the next question is, my mother passed away in October of 2020 without a will. Her house and property are in her name only. However, her husband, I'm guessing not the questioner's father, got a mortgage against the house in 2015. Unfortunately, he began doing strange things, and the questioner's sister had him picked up and hospitalized under the Baker Act. It's been determined that he does not have the capacity to consent. He was diagnosed with several mental health issues, and the house has not gone through probate. What right do I have the right to petition for the house to go through probate? And I saw a bunch of other issues in there, but I'll let you start with that question.
Definitely, she would be an interested party that could open the probate. But the question then becomes, do you? If the stepfather got a mortgage out on the property in 2015, we're 7 years into the good with that. So some you would expect, depending on how much that mortgage is, really is what makes me, my answer to the question really depends on how much was loaned. I mean, did the stepfather take out the maximum amount that the lender was able to do? So there's little to no equity after all this time. If so, by probating, that the loan's still going to be there. So I'm assuming that the loan's still there. There's been 7 years of payments that have been made. So there's been some, there's some equity there, but does this person want to open up a probate to then become the owner of it? And they'll be the lucky winner of a mortgage that still has to be paid. Or generally what happens is then you sell the property. But do you go through all that exercise to sell the property only to find out that you're getting nothing? The bank can't come after the beneficiary for any deficiency, but it just depends on what is the loan balance. And if he only took out like a $30,000 loan, like a home equity loan, then then maybe if there's enough equity there, then it's worthwhile to open up the probate. But regardless of whether it's worth opening probate, she is an interested party and has the ability to open up the probate.
So Ian, the individual put in there, there's a little over 20,000 owed on the mortgage, and her and her family are willing to pay off the mortgage.
Perfect. Then I would say it's definitely, with a balance that low, then I would say, that there's, I'm assuming, if it's a single family dwelling, then it's probably got some significant equity. Then open up the probate and have especially given the type of property, then it would, the stepfather is going to still, just like at the very beginning that we talked about, if this is truly the stepfather, he would have a right to either 50% of the home, or he could take a life estate. But given his current medical issue, if he's not there, then it sounds to me more like that what would happen is that he would be an automatic, because you're automatically a 50% owner. You have to elect to take the life estate. And if he's not of the right mind to be able to take that election, then he's going to be a 50% owner. The other family members or children would be 50% owner. Then they could turn around and sell the property, and then half of it goes to the stepfather for his care, whatever's going on, and the other half would go to the children.
Okay, great. I'm going to leave the chat open for another couple of minutes. Let anybody filter through with any questions. We've already covered quite a lot of material today. Usually you have prepared remarks and we get very few questions. Today it's been all questions, and I don't think you've gotten to any of your prepared remarks.
The thing I would say is that you do, what we have learned from some people, what I can tell, had wills, some people didn't have wills. So it's important whether you hire an attorney to do it, or whether you go on LegalZoom, or you go to Office Depot, or whatever you go. It's important that you have a will, so that way you can choose where your assets go, even if by default what you would put in writing would be the same thing as if you didn't have a will. It's just better just to have one in place, because people's lives change, and maybe you've got, especially if you've got multiple, if you're in your second marriage and you got a blended family of kids, then you definitely want to have one. And if you are if you're a young couple or a person that has children that are minors, it's very important that you have a will, because you need to have somebody that's going to be the guardian of the minor child, and who's going to be the trustee of the monies that you leave behind. If you don't have that, that gets into some very expensive proceedings because now the court has to decide who the guardian's going to be if there's no biological parent that's left, and who's going to be then the trustee of the monies that are left behind for the minor children. So so it is important to get a will.
And then it begins all sorts of romantic comedy movies.
Yes.
I can think of at least 2 or 3 off the top of my head. But yeah, we at Legal Services are big fans of people doing their wills. We are trying to get caught up on our very backlogged cases of clients looking to get wills done. So any attorneys watching, if you want to volunteer to help out at one of those clinics, please let us know. And any clients who are looking to get a will done, please contact Legal Services at lsnf.org and fill out our application, our intake, or obviously you can call our offices. Our main office number is 850-385-9007. One of our attendees asked if he's allowed to ask another question. You absolutely are. If everyone in the family agrees on what to do with the property, does he need an attorney, or can he simply fill out the appropriate forms and submit them?
Yeah, if we're dealing with, again, just the homestead, or if in addition to the homestead, we're just talking about some personal property that is under the $75,000 threshold. So if you're in what I call summary administration land, then yes, you don't need an attorney, and you can file the appropriate petition and other paperwork to have that done. But if it's formal administration, the judge won't let you. You might get away with filing the initial petition, but as soon as the judge is assigned and they see that it's a formal probate, they will send out a notice to the petitioner and tell them that they have to hire an attorney if it's a formal administration.
Yeah, he says it's a homestead worth about $200,000.
Yeah, I'm not worried about the value. If it's homestead, it could be $3 million. It's the homestead value is completely exempt from the $75,000 cap. The $75,000 is everything other than the homestead. And the other issue is that even if you have assets that exceed $75,000, that's not including the homestead, but the person passed away 2 years or more, you can do summary. So that's the difference. So there is a situation, but if it's a recent death and the assets are over 75,000, not including the homestead, then you are in formal administration land and you would need to have an attorney file that paperwork.
Okay. We have another question, and I think this is a really good and important one, so I really want you to answer it. The question is, what's the benefit of having a payable upon death account?
Very important. So,
right?
Yes, because I handle a lot of probates where that didn't happen, and you could have avoided so simply by just having a beneficiary designation in place on those accounts. So, you may have it in place and then you change banks and then you forgot to do that. So it's important to check those investment accounts. Most of your life insurance policies or other retirement accounts, they automatically have those forms, and I wouldn't say force you to put a beneficiary in, but it's part of the setup, the paperwork that you're filing. But with banks, most, when you're opening up an account, they're not asking you who's going to be the beneficiary. They're just happy that you came to them and open up an account with them. So you do need to check and make sure that there's a pay on death, or they call POD, or just what they call beneficiary designation. Some banks will let you do 2 levels. So you can have a primary beneficiary and then a contingent beneficiary. If they'll let you do that, I highly suggest that. It keeps you from having to go back to the bank if there's a death of the primary, and then you never got around to fixing that. That happens, or let's say that it's a husband and wife and they were in a common accident, then now there's no beneficiary. So I would, if you can do a backup beneficiary, I would suggest that you do that. So very important to have that in place.
I agree. Yeah, it's definitely something we recommend every time.
Especially if you're doing online banking now, it's more important. It's when you had the brick and mortar places and you went in there, occasionally the paperwork, you at least see a beneficiary line and you could write it in. But we can go open up accounts now online in less than 5 minutes, and you're just putting in the basic information. And I've opened up several of them myself, and not once did I see a question that asked me, who do I want to be the beneficiary of this account? It's there, but it's not part of the application process. So for those out there that have online accounts, you need to go in, log in, do it tonight, and go into your settings and make sure that there's a beneficiary in place.
Great. Let's go ahead and move on to the forms and what the Leon County Clerk's Office can do to help, and then we'll discuss the specific forms that you would need to file for a summary administration.
Well, since we're doing this clinic online, I'd like to start with what you can get online. So I'd encourage anybody with an interest or a need to look at what's available in the way of probate forms to look up the clerk's office. You can go to www.leonclerk.com, or if you're like me, simply just Google Leon County Clerk and then bookmark it so you can find it again. But you would go to our main page and you'll find there's a series of tiles, and along the top row of tiles to the very right side, there's a tile that says forms. Simply click on that, and then you'll see a screen that gives you a list of court types on the left. Simply click on probate. That's the fastest way. And then you'll see a series of forms that are available, as well as a set of questions that will not as excellently answered as Ian just did. They're out there and they're available to provide some basic information. So I know you mentioned, what do you need for summary administration? Well, in our probate forms and assistance list, there is a summary administration checklist. So I'd encourage you to get that and take it and just start going through it and start filling it out. And if you need assistance, I'd encourage you to call legal services or Ian, or if there's an attorney that you work with, and to get advice as to how best to fill that out. There's also
Ken,
I'm sorry. Colleen?
I was going to say, will the Low Bono Center help with those forms as well?
I wish we were. At the Low Bono Center, we're assisting customers with small claims cases, landlord-tenant cases, and family law cases. So I wish we were doing probate. It's just, it's probably more of a challenge to get attorneys that specialize in probate to come and donate their services at the Low Bono Center. But that would be something I'd love to do at some point in the future. And that's why I'm really appreciative of Colleen and Ian putting this together, because we do get a lot of questions about probate. And, we are limited in what we're authorized to provide in the way of information. We can explain the process, we can show you the forms, but we're very, very limited on any kind of advice that we could provide. And so I'd encourage you to read what's available on the site, particularly in regards to probate. Look at the forms. And if you have any doubt, I think it's always worthwhile. A lot of times you can get an initial consultation for no cost or very low cost. And I'm very confident that that would be a good investment of time and money. It would save you a lot of time and aggravation in the future to go down that road. And I think there's some services available both locally and through the state bar, where you can post questions online, or you can get a referral for just that purpose. So I'd encourage people to do that. We also have online a for summary administration a summary consent form. I would encourage people to use that. I think that might be helpful in cases where you have several folks that are beneficiaries, and one of those will be the main person working on the case. So again, Ewan would be the one to answer that question. But we have a number of forms there and a number of questions and answers, and I encourage people to use those. If you want to come down to the courthouse, and the courthouse is open, you're welcome to come to the clerk's office, to the help center. We have a series of terminals and a staff in there. And the reason you might want to do that is to get access to it. If you've opened a case file, you can certainly come down and see the case in the clerk's office. However, you can also see that case from home by going again to the main page, and this time going down to the lower right-hand corner of our set of tiles and click on Secure Web Registration. The reason you'd want to do this is then by filling out that form and sending it to us, or bringing it in and having a deputy clerk sign it for you, we would be able to give you access to your probate case, and you'd be able to see that online. We do have cases online, but we're not able to provide probate cases for anonymous public search. Probate cases are considered sensitive cases, and you would need to be the party of record or a registered user to be able to view any of those files. So again, that's another way that you could keep up with what's been filed in the case, any court events that have been scheduled, or anything that's been filed that would need to have a response prepared. So I encourage people to take advantage of those resources in the clerk's office. You can always call our office. We have a staff that works in probate, and you can also ask them questions. And again, they can give you general process answers and point you towards resources.
We have a few more questions if y'all are willing. The first one is, what are the different tiers of paying creditors in a probate, or should I immediately start paying creditors upon death?
Do not immediately pay creditors upon death. First, if you're paying out of your own pocket, you have no legal obligation to pay the debts of the deceased, even if you're the spouse. I mean, unless the debt is a joint debt, like if it's a credit card debt and you were the authorized user on the credit card company is going to take the position that the surviving spouse also needs to get it paid. But for all things being equal, if you're not an authorized user on an account, or if it's some other debt that was just in the name of the deceased, then you really need to have like a pause, just a take back, look at everything, focus on first your grieving, so you're dealing with that. Then you've got to deal with getting the documents together, and not every creditor is going to file a claim in the estate. You know, probate's kind of like a little, the same way bankruptcy. If you want to have a seat at the table, you got to file your claim in the probate. Otherwise, you don't get a chance to get paid. Just because you file a claim doesn't mean you're going to get paid either. I understand especially if it's a small amount, there's this, from a moralistic standpoint, I get it. People want to just get it paid. It said, hey, the person owed the debt, I want to get it paid. But you don't want to start paying people out of term. So you run the risk of starting to write checks, getting people paid, and then not having enough money in the estate to pay all of the claims that come in. So that's another reason why you really need to, you wait, you open up the probate, the creditors will receive notice. The way they receive notice is either they get a certain form that's mailed to them directly. And if that happens, then they have 30 days from the day they receive it to file a claim. If you don't know of a certain creditor, they publish it, and then they have 90 days to file a claim. They don't file a timely claim, even if the claim is legit, then legally there's no obligation to pay it. And so whoever is the executor, the one that's handling the estate, that's why you don't start paying stuff right away. You want to take care of the creditors that have filed timely claims first. And then if there's money left over and you want